വെൽക്കം ബാക്ക് ടു മൈ ചാനൽ. അപ്പോൾ നമ്മൾ ഇന്ന് നോക്കാൻ പോകുന്ന തഹസിൽദാർ സീനിയർ സൂപ്രണ്ടൻറ്റ് സ്പെഷ്യൽ ടോപ്പിക് ക്ലാസ് 2 ആണ്. അപ്പോൾ ക്ലാസ് സ്റ്റാർട്ട് ചെയ്യുന്നതിന് മുന്നേ ചാനൽ സബ്സ്ക്രൈബ് ചെയ്യാത്തവർ സബ്സ്ക്രൈബ് ചെയ്ത് ആ കുഞ്ഞ് ബെല്ലൈക്കണോടൊന്ന് പ്രസ് ചെയ്യണം. എന്നാലേ ഞാനിടുന്ന എല്ലാ വീഡിയോസിൻ്റെയും നോട്ടിഫിക്കേഷൻ നിങ്ങൾക്ക് കിട്ടത്തുള്ളൂ. അപ്പോൾ നമ്മൾ ഇന്ന് നോക്കാൻ പോകുന്ന പബ്ലിക് ആൻഡ് പ്രൈവറ്റ് ലാൻഡിൻ്റെ മേജർ ലോസ് ഗവർണിംഗ് ആൻഡ് ഇറ്റ്സ് അഡ്മിനിസ്ട്രേഷൻ. കഴിഞ്ഞ ക്ലാസ്സിൽ നമ്മൾ ഇതിൻ്റെ ഡിഫറൻസ് ബിറ്റ്വീൻ ആണ് നോക്കിയത്, പബ്ലിക് ആൻഡ് പ്രൈവറ്റ് ലാൻഡിൻ്റെ ഡിഫറൻസ് ബിറ്റ്വീൻ. അപ്പോൾ നമുക്ക് നമ്മുടെ ടോപ്പിക്സിലേക്ക് പോകാം. Land is an important source of identity, symbol of social status and foundation for rural power in India, often carrying significant emotional attachment. With a long history, diverse geography and pluralistic culture, land governance has evolved in India through communal, imperial, feudal, colonial and modern system, gradually moving toward individualism and conclusive titling. Contemporary land tenure is dotted with mosaic of customary tenure and community ownership in tribal and hilly areas, and dwellingly rural common lands amidst expanding of privatized space in urban and industrial areas getting converted from once predominant forest and agriculture landscape. Indian land governance is at a transition between nations' economic growth aspirations incumbent upon making land available for investment, while the socialist state is committed to an agenda on land and forest reforms that allocate to and recognize the rights of landless and tribal respectively on government and forest lands. Environmental concerns restrict diversion of forest lands and promote expansion of protected areas. Land conflicts are on the rise as a result of competition, continued lack of tenure clarity around common lands, and increasing demand for higher compensation for private lands, which bottlenecks investments. Land governance in India in the post-independence period has evolved as a state subject, with the Land Revenue Department as the main custodian, while the actual responsibility is shared by number of departments and agencies at the state and local level, making land governance complex with overlapping jurisdictions. These are high transaction costs to assess and transfer land. Land-related disputes constitute more than half of disputes in civil and a significant number in criminal court cases, which are often dragged for long duration and drain private and public resources. Federal and state governments have brought its many institutional innovations, adopted new technologies to improve land record management, promote women land rights, facilitated alternate disputes resolution, and are now contemplating tenancy reforms. The last 70 years of land governance can be broadly divided into four phases of reforms. That is, first one, land reform aiming land to cultivators during 1960s to 80s. Second, attempts at involving local self-governance institutions through decentralization of land governance. Third, digitalization of land records aiming at conclusive titling in the early 21st century. And fourth, forest land acquisition and tenancy reforms occurring mostly in the current decades. Land legislation and regulations. In the Constitution of India, land is included in the state list and forest under concurrent list, both state and central list. Land and land reforms are under the legislative and administrative jurisdiction of the federal states, while both the union and the state have jurisdiction over forests. Originally, the rights to property was the fundamental rights under the Constitution of India till the year 1977. After 44th Constitution Amendment in 1978, the right to property no longer remained a fundamental right but instead became a constitutional right, protected under authority of law. Special provisions are made for protection land tenure in tribal regions in the 5th and 6th scheduled area. In the six scheduled states, no act of parliament can affect the customary law and ownership and transfer of land. Soon after independence in 1947, land reform initiatives carried out in accordance with the socialist agenda of the state aimed to abolish zamindari, impose land ceiling, promote land distribution to landless and consolidations of holding. The laws enacted for the abolition of estate or jamindaris and intermediaries by 13 states were listed under 9th schedule in first constitution amendment in 1951 in order to avoid challenge in court by landlords. Two important pieces of legislation were passed recently in the 21st century. This law followed a reformist approach and had a substantive impact on land governance in India. As a progressive forest tenure reform, the Forest Rights Act 2006 provides a legal framework for recording and vesting of forest rights to scheduled tribes and other forest dwellers whose rights were not recognized earlier during settlement of forests in colonial as well as in independent India. About 40 million hectares of forest land in one-fourth of village in India can potentially be registered under FRA in favor of community and individuals. This potential makes the FRA possibly the most impactful land reform in India of this century. The second law, the right to fair compensation and transparency in land acquisition, rehabilitation, and Resettlement Act was brought in 2030 after several rounds of parliamentary debate to replace the allegedly draconian Land Acquisition Act of colonial India and make land acquisition fair and just. It provides compulsory rehabilitation and resettlement assistance to affect families, enhance compensation for farmers with expanded coverage of compensation, and grant compensation to non-owners facing loss of livelihood. With free prior informed consent of Gram Sabha made mandatory for acquisition in scheduled areas under the 5th schedule, along with the requirement that affected families must give prior consent to proposed acquisition by the private section. RFCTLAR has drawn apprehension, worth, and alcohols from different stockholders. It also prescribes carrying out social impact assessments to determine a project impact on people's land and livelihood in consultation with the PRI. Protection of right of ownership over land in state law. The land rights of persons are protected and regulated in the state laws. Different states have made protective provision to check and restore any illegal transfer of land of socially vulnerable group under state land reforms laws. States in Schedule 5 areas have empowered the governor to make regulation for protections of tribal land and have enacted legislations relating to prevention, prohibition of land transfer by tribal to non-tribal, and in some cases even restricted transfer of land between tribal inter Section 7 Odisha Amendment to the OSAT IP Regulation 2 of 1956 in 2002 completely bans transfer of immovable property of STs to non-STs in scheduled area. Andhra Pradesh has gone on a step ahead, explicitly prohibiting any person in scheduled area from transferring lands to anyone other than a scheduled tribes. The state of Karnataka has banned any transfer of lands allotted to landless agricultural laborer belonging to SC/STs without the knowledge of guarantee. However, in most of the cases, the provisions of these laws are poorly enforced in practice. The provisions for suo motu cognizance soon after illegal transfer are not followed or provide time-bound delivery of justice. Escalating tensions, growing insurgency, and inter-community feuds are conspicuous in tribal areas due to poor enforcement of protective laws. Now let's see land tenure classifications. Three land tenure systems found in India were based on revenue collections: Zamindari, Raitwari and Mahalwari system. The post-independent Raitwari type of tenure system continued as the title holders were in direct relationships with the state for land rent. Subsequently, land rent systems were abolished with only provisions of payment of a nominal cess. India's land tenure typologies are complex due to adoption of historical legacy, compulsions of welfare state and emerging economic development. Three main types of tenure in the country that govern land ownerships and use: private, government and common lands. Private land. Various types of private land tenures exist in LA includes land owned on inheritance with transferable and heritable rights. Second, land granted to cultivators on lease by government or other with permanent right of possession with or without right of transfer. Third, land leased in tenure without any permanent right of possession classified in terms of fixed money, fixed produce, share of produce and unfrequency mortgage. Fourth, allotment of government wastelands to landless tenant and house sites to homesteadless families under government land distribution scheme, and also include cross-cutting the women's rights over land and joint title in the name of both the spouse. Additionally, in the context of alienability or transferability, two types of private land ownership rights exist: freehold and leasehold, which are relevant both in urban and rural areas. Private tenure could also include religious institution, endowment land in the name of deities and religious trust, temples, waqf board, churches, madrasas, devotees and Brahmotra land, etc. Some of these are called service tenure, as the land ownership are linked to service offered by some individuals to the deities. Now we will see about the government land. In India, government land is held by central ministries and agencies: State Revenue Department, State Forest Department, Railways and Defence, other state department or government institutions, and institution of local self-governments in urban and rural areas. The state of Karnataka uses the term public land for government land and established the Karnataka Public Land Corporation Limited as the body in charge of managing these lands. Central and state departments and organizations are the largest landowners, but there is no publicly available information on those land holdings. The forest land reserved or protected are under the ownership and management of forest departments. Enactment of FRA created a new category of forest overlapping across all types forest of the community. Forest land within the revenue boundary is under ownership of revenue department, where management is entrusted with forest department. Lack of land registry database for government land both in urban and rural areas, and little information on the extent of government land transferred to private interests. In India, the systems of customary tenure exist in codified and oral forms and are practiced more in the tribal region than among mainstream societies. In the northeastern states, provisions of 6th Schedule and other special area articles of the Constitution protect local customary as well as community land tenure systems. Diversities of tribal communities in their ethnic origin, culture, language and customs are also reflected in their customary law and land management systems. In Hindu Succession Act 1956, the son had complete right over their father's property, while daughter enjoyed such rights only until she got married. In 2005 amendment, every daughter as member of Hindu joint family, whether married or unmarried, has the same rights to her father's property as the son. However, if the father died before the force of such amendment, her right to ancestral property does not arise, since law does not provide retroactive effect. Now let us see land use change. A ninefold land use classification has been adopted in post-independent India. Since 1950, the area of non-agriculture use has been steadily increasing, with falling in cultivable wastelands, which now constitute 8% of the geographical area, almost tripling in 60 years. The areas under rural Land use has reduced from 72% to 64%. There is a lack of separate reporting of urban land information in absence of availability and maintenance of urban registry and cadastre on base map in most states. Urban population was 31% in 2011 with 2.38% rate of urbanization. Satellite-based analysis indicates that majority of urbanization occurred in cropland area while 0.12 mha of forest areas were cleared for urban development during 1880 to 2010. During the period, the built-up areas has increased by five-fold from 0.46 mha. The urban population is expected to increase by more than 200 million by 2030, which may require 8 mha of additional land for residential use alone. Now let's see land record management. Accurate land records are crucial for effective enforcement of well-defined property rights, reducing the scope of disputes and aid in dispute resolution. However, complex procedures involved in land record management and the infrequency of surveys and settlements make land records old and outdated with a poor accessibility. Additionally, more human interface adds transaction costs to service deliveries. To develop a comprehensive and transparent land records management (LRM) system for conclusive land titling, the Government of India launched National Land Records Modernization Program in 2008, merged with two previous central-sponsored schemes, renamed as Digital India Land Record Modernization Program. The scheme has three major components like computerization of land records, survey, resurvey, and computerization of registration. It aims to usher in a system of updated land records, automated and automatic mutation, integration between textual and spatial records, interconnectivity between revenue and registration, a replacement of the present deeds registration and presumpting titling system that provide conclusive titling with title guarantee. Its core focus is around providing a single window to handle land records, the mirror principle, the curtain principle, and the title insurance. The process of digitalizing land records started in 1988 and accelerated from 2008. Now DILRMP covered all states and union territories. As on 23rd Jan 2014, 23 states has computerized registration process. 21 states completed computerization of record of rights, accorded legal sanctity to computerized copy of RORS and started mutation using computers. 17 states stopped manual issues of record of rights. 9 states introduced e-stamping and integrated their land record with registration process. 18 states in India now issues ROR from Tehsil's Computer Center. 12 states issues ROR at town, village, KISOC's Common Service Center, and 6 states issues digitally signed RORS. Implementation of DILRMP is challenging and time-consuming and largely funded, targeted, and center-driven. States have different languages and terminologies for property records, including various methodology for preparing land records, and have progressed as per priority, legacy, and capacity. Many states, through Public Service Delivery Acts brought in these decades, are trying to introduce systemic change by making public delivery system accountable, efficient, corruption-free by fixing delivery times for registration, mutation, issuance of records, and allowing access to certified copies. അപ്പോൾ നമ്മുടെ ഇന്നത്തെ വീഡിയോ ഇത്രയേ ഉള്ളൂ. ഇതെല്ലാവർക്കും തഹസിൽദാർ എക്സാം, സീനിയർ സൂപ്രണ്ടൻറ്റ് എക്സാം പ്രിപ്പയർ ചെയ്യുന്ന എല്ലാവർക്കും യൂസ്ഫുൾ എന്ന് വിചാരിക്കുന്നു. അപ്പോൾ എല്ലാവർക്കും വീഡിയോ ഇഷ്ടപ്പെട്ടെങ്കിൽ ലൈക്കും കമൻറ്റും ഷെയറും ചെയ്യാൻ മറക്കരുത്. അപ്പോൾ അടുത്ത വീഡിയോ ഉടനെ തന്നെ ഉണ്ടാവും. അപ്പോൾ നെക്സ്റ്റ് വീഡിയോ കൊണ്ട് വരുന്നവരേക്കും എല്ലാവർക്കും ബൈ, ടേക്ക് കെയർ.